everyone. Welcome to this webinar on claims under IBC, Important Aspects and Intricacies, organized by Committee on Insolvency and Bankruptcy Code of ICI. We have with us the Chairman of the Committee, C.A. Gyan Chandra Mishra ji, our Vice Chairman of the Committee, C.A. Rajendra Kumar ji, and the Speaker for the session, Advocate Madhusudan Sharma ji, and the Moderator for the session, C.A. Vishnu K. Tulsian ji. Welcome to all of you, sir. I would now request our Chairman of the Committee, Gyan Mishra ji, to please address us on this occasion. Over to you, sir.
So much thank you, Madam Rita, Honorable Secretary of the Committee, my good friend and my younger brother and of course Vice Chairman of the Committee, C. Rajendra Kumar ji, very learned speaker of today's program, Madhusudan Sharma ji, a very young and vibrant, Secretary of EIRC and of course moderator of today's program, Tulsian ji, and very respected all the participants. Good afternoon to one and all. Friends, we all know that Insolvency and Bankruptcy Code has taken a very vital role so far in the economical development as well as reforms and restructuring of the financial sector of the country. The claims, which is very important part of the entire code, rather we can say, this might be the soul of the code, that need to be discussed elaborately, and no other than this very learned speaker than Madhusudan ji could be for the same topic. Claims with regard to the financial creditors as well as operational creditors, the timeline, how to admit, when to admit, what could be the criteria, and what might be the justification of if the claims are not admitted in time, and what could be the role of the honorable adjudicating authorities in case the claim is not admitted in time. All those needs to be discussed and will be certainly discussed today. Friends, recently some important facts came in the knowledge of the committee that while undergoing some of the grievances under triple IPI, we came to know that few of the financial creditors, especially the class of creditors, they have gone to the honorable NCLT for admission of their claims in few of the cases. The cases are being heard, and the claims are again referred back to the resolution professional. Those need to be seen very judiciously, and that need to be addressed in such a way so that the spirit of the code with respect to the classes could be met out. The session is really very interesting, as the claim is very important aspect of the code, and I'm sure that this will benefit to each and every member of the webinar who are participating over here. One more thing that I would like to request to all the participants, any one of you who wants to be speaker, moderator, or who wish to write on any topic of the IBC, please come forward. The committee is looking for various types of knowledge dissemination programs and sessions, including the articles from the participants. And this would be indeed a great encouragement to the committee, because Rita Madam is working day and night, and one monthly newsletter, e-newsletter, has been launched by the committee and in the name of Knowledge Capsule, and that has been spread to all the members across the country through the mail. I'll not take much time as our learned speaker is waiting, and our respected Vice Chairman is here, and of course the moderator is also ready to take the session ahead. I compliment Rita Madam for taking the initiative for such programs in the interest of the members of the institute, and of course all other stakeholders who have joined this program from different locations of the country. So Rita Madam, congratulations and kudos to you for taking the initiative for such programs in the interest, and I'm thankful for giving this opportunity to interact with the learned professionals of the insolvency profession. So thank you very much, one and all.
Thank you. Thank you so much, Chairman Sir, for sharing your valuable perspective and thoughts with us and setting the tone for the webinar today. With this and with your permission, now I would request our Vice Chairman of the committee, say Rajendra Kumarji, to please address us, sir. Over to you, sir.
The very dynamic, hardworking, and efficient chairman of our committee, CA Gyanchandra Misra ji, who a few months before was successful in conducting a conference of the insolvency in Singapore. In fact, let me tell you, ladies and gentlemen seated here, that was one of a significant epoch-making event in the history of the committee. And I must sincerely congratulate my chairman for leading from the front, I must tell, leading from the front in that particular event and ensuring that the flag of the Institute of Chartered Accountants of India in general and the committee in particular was held high. Ladies and gentlemen, I recognize the presence of our faculty, Advocate Madhusudan Sharma ji, and also the efficient and hardworking secretary, Rita madam. Today's topic is claims. Esteemed friends, you will be aware that claims form a significant part in the IBC process. In the process of insolvency resolution, claims form a significant process. Whether it is an operational claim, whether it is financial claim, or whether it is any other claim, the resolution process success depends on the success of clearing the claims also. In fact, how the distressed entities' assets will be distributed among creditors, stakeholders, the resolution professional has a very significant role to play in this. Friends, there's a structured and time-bound process for resolving the insolvency, ensuring that the claims are addressed fairly and efficiently. Our very erudite speaker today, Advocate Madhusudan Sharma ji, who hails from the pink city of Jaipur, Rajasthan state in India, is here with us, who will be deliberating this particular entire process. We also see on our screens Tulsian ji, who is from the Eastern India Regional Council, a person who has a very dynamic insight on all these processes. They very recently concluded a conference, 2-day conference on insolvency in Kolkata. I recognize your presence, Tulsian ji, Vishnu Tulsian ji, and also thank you for being with us, sharing the screen space today. Thank you all. Thank you, Rita madam, and best wishes to you and also to all who are participating in today's program. Thank you once again, Madhusudan Sharma ji, for sparing your valuable time. I know how valuable the time of an advocate is. And our chairman leading from the front, wherever he is available. We can see him on the screen with a wonderful background of nature. So thank you very much. Over to you, Rita madam.
Thank you indeed, Vice Chairman sir, for sharing your insights with us and bringing forward the very important aspect of IBC, which is time-bound process. Thanks indeed to you, sir. So before moving to the session, I would take this opportunity, sir, to introduce briefly the speaker and the moderator of the session. First, I would like to introduce Advocate Madhusudan Sharma. He is practicing as an advocate and insolvency professional with over 40 years of diversified job and consulting experience. He had been consultant advisor in several projects funded by agencies like the Asian Development Bank, World Bank, European Union Department for International Development, Government of UK, etc. As a consultant, he has been associated with a number of large international and national consulting companies. Also, he is a regular faculty for training for insolvency professionals by IBPI and insolvency professional agencies. He has been a guest faculty for graduate insolvency program, the Indian Institute of Corporate Affairs at Manesa. Welcome to Madhusudan sir. And now I'd like to introduce the moderator of the session today, CA Vishnu Kumar Tulsian. He's a chartered accountant and company secretary with 2 decades of professional and practical experience in the field of corporate law, stock exchange, NCLT, audit, taxation, and financial matters. He speaks on various topics like Companies Act, NBFC regulation, LLP Act, income tax. He also regularly writes
who is from Jaipur and who will share his knowledge on the claims, because this is a very important part of the process. And before that, I just want to thank the first chairman of the IBC who took ICI to the foreign land. And so back. And sir, to be very honest, when I members IBBI were there and they were missing. Yesterday I was in Delhi and I was in the chamber of Gyanista sir, and I said the same thing with them. That sir, we missed you, although it is very important program. So in future we would like to bring such a program again. Speaker sir, normally friends we face the problem of filing of Form B and Form C in different sections, sections 7, 9 or 10. Nobody thought of it that claimant file a wrong forms or they do not make a proper attachment. Or even if they make proper attachment, they do not authorize a certain person who can take the decision. And due to such reasons, we are unable to make a committee of creation because of wrong forms. And after that, some people rightly go to NCLT and they say that the RTO has not accepted our claims. So this type of dispute. In this case, it is very important that the claim should be verified within a time and accurately, and after that we should verify and also we file a report on this claim to the NCLT in the proper time, so that the system may be very smooth and it becomes transparent. And for to discuss this matter, we have Master Sharmaji and Deputy in detail. And I request everyone to please put up a query because let the speakers know that whatever problem you face day to day in the NCLT proceedings or in your day to day process of the dealing with the CD, so that the lack of transfer should not be there. And for that, I request Master Sharmaji to please take the deliberation ahead. Over to Sharmaji.
Thank you, Ritaji, for the link between the committee and the speaker. And thanks to the committee comprising of leaders leading from the front, as Rajendraji told. So this is a good opportunity to interact with the professionals on a very important topic like claims. As Gyanji mentioned, claim is the soul of IBC. But if you ask from the perspective of an insolvency professional, claims are the most challenging and strenuous responsibility of the insolvency professional. Given the timelines, given the known no cooperation from the promoters, because at times the IP will be wanting for the records to verify the claims. And on top of it, IBC has been dubbed as a very dynamic legislation. And it is too dynamic, like the changes are very frequent. So it's very difficult for the IPs to keep track of the changes related to the regulations, rules, or IBC. So that all coupled with the makes it still more challenging. And recently we had an amendment in the CRB regulations, which was mostly on the claims, and it will add to the responsibility of the IPs, the way it has been modified to address the issues of timelines and delays. So now we'll go stepwise using the PPT. And if you have any queries or anything which you want to know in between, you can make a mention of it, and Tulsianji will intervene if so required. Otherwise, at the end, we'll have the question answer session. So I'll just share the PPT and we'll go with that. So please confirm that the PPT is visible.
Yes, sir. It is visible, sir.
Thank you. Apart from the procedure part,
You may put it on the bigger screen, sir.
screen.
Yeah.
We will take up the key issues related to claim filing. And this is not limited to the list which I am displaying here, like the admission or rejection of a claim, timelines, default amount, classification as a financial or operational creditor, loan without interest, treatment of interest and panel interest, disputed claims, claims of the beneficial owners, or where the documents are with inadequate stamp duty, claims against the bank guarantee, and corporate guarantee. So first, let us see the definition, what a claim is. Section 3 defines, and the most important part, which will help us in interpretation of other judicial pronouncement, is that there has to be a right of payment. For making a claim, right of payment is the prerequisite. In both parts of this subsection, says a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. So all are treated uniformly. Everyone can make a claim, whether it is disputed or not, whether it is fixed or not, whether it is equitable, secured, or unsecured. It encompasses all types of creditors. The second thing is right to remedy. For breach of contract under any law for the time being in force, if such breach gives rise to a right to payment. A breach without any right to payment will not be the subject matter of claim. So in both the cases, there has to be a right to payment for the creditor, then only he can make a claim. The next part is debt. Just a claim will not suffice. It has to be a debt, and that which is payable. So debt means a liability or obligation in respect of a claim which is due and from any person, and includes a financial and operational debt. These wordings will at times create some confusion when we are interpreting the law, because different types of classifications have been used in different definitions. To simplify the understanding what is a claim and what is a debt, Honorable Supreme Court has given a very brief guideline in the famous case of Swiss Ribbon, which says, claim gives rise to debt only when it is due. So if there is a claim which is not due, will not become debt. And the default occurs only when the debt becomes due and payable and is not paid by the debtor. This was, of course, with a reference to the application for initiating CIRP, that when a debt is in default, the application can be initiated. But this will also help us understand the issues relating to claims and debt, even during the claims being filed by the creditors in the CIRP process or in the liquidation process. So I hope the difference between a claim and a debt is clear. That will be the genesis of all our discussions henceforth. Now, when does the need of claim arises? Under IBC, there are several processes. If we divide it into broad two categories with reference to the affected parties, it is the corporates and the individuals. In case of corporate, there are three processes. Corporate insolvency resolution normal process, corporate insolvency resolution fast track, liquidation, which is compulsory in case the corporate insolvency resolution fails, and the third process is voluntary liquidation. In all the three processes, there is a prescription or there is a requirement for the creditors to file claims within a given time frame. So this will be applicable even to individual insolvency and bankruptcy. At every stage, claims are invited. We will focus more on the corporate processes, which includes CRP and liquidation. Now, first, let us understand the duties of an insolvency professional, how the IP is supposed to function, what the IP is supposed to do, and how he is to do. The duties of insolvency professional in the role of interim resolution professional and RP and as a liquidator are defined in a quite different fashion, and which has led to the observation of Honorable Supreme Court in Swiss Ribbon case that RP is not an adjudicatory authority, unlike the liquidator is. And what is the reason for that? Why did the Supreme Court came to that conclusion? Is based on these duties. So let us see the duties. As per section 18, the duty of RP is to receive and collate all the claims submitted by the creditors. And based on that, our IRP will constitute a committee of creditors, and then it is to maintain a list of updated claims. So that is the role and responsibility of an insolvency professional in the position of interim resolution professional or RP. Now, what is the duty of liquidator? In terms of the duties for the liquidator, there is a change which makes it quite different from the role of insolvency RP. Here it says to verify claim of all the creditors, and after verification, admit or reject the claim. So the words admit or reject the claim are not available in the duties of RP. That makes the difference. And we can compare it here. RP is to receive and collate all claims, whereas the liquidator is to verify the claims and then either admit or reject the claims. And because of this basic difference in the wordings of the provisions related to the duties of RP and the liquidator, Honorable Supreme Court has come to the conclusion that RP does not have any adjudicatory power. On the contrary, the liquidator has adjudicatory power. The liquidator can admit or reject a claims. The RP cannot admit or reject a claims. RP has to collate the claims. But then there will be a question that if the RP doesn't have power to reject a claim, does it mean that RP will take all the claims, whatever way they have been filed? It is not so, because there are provisions which requires the RP to verify the claims with reference to the documents submitted. So in case the documents are not sufficient to prove the claim of the creditor, RP has a right to ask for more details. And if the details are not submitted, then RP can admit the claim in part, or others, instead of saying admit or reject, we can say that RP can collect the claims in part, which is supported by the documents. So the observation of Honorable Supreme Court was that RP is given administrative as opposed to quasi-judicial powers. As opposed to this, the liquidator has to consolidate and verify the claims and either admit or reject such claims. So there is a basic difference between the role and responsibility of an RP. When I say RP, it includes IRP and that of the liquidator. This we should always keep on mind whenever we are deliberating about the different issues related to the claims. Now, timeline is the most important issue, which is often litigated. IBBI, through the regulations, have put very stringent timelines for the RP to verify the claims, and that is within 7 days of receipt of the claims. The IBBI regulations with respect to the timelines of claim have also been changing over a period of time. Similarly, the judicial pronouncements have also taken different overtones. depending on the different phases of the CRP process and depending on who are the claimants, whether it is home buyers or other creditors. Generally, the adjudicating authority adopts a very lenient approach towards the home buyers because of the situation they face in putting their whole lives savings in investment for a small house or a big house. So this is the most important aspect of the claims relating to the timelines. Now, timelines, as far as the IBC is concerned, is with reference to two major segments. One is the timelines for submitting the claims to the RP, either in the capacity of IRP, RP, liquidator. And the second thing is the timelines with reference to the law of limitation. Both the things are relevant for accepting claims, and we will discuss these issues with the judicial pronouncements for a better clarity. And maybe sometimes because of different opinion by different benches of the NCLT, it may create a confusion also. Now, in terms of the timelines, section 15, subsection 1, which deals with the public announcement, leaves it to the regulations. It says the last date of submission of claims has to be informed to the public at large when the Form A is being published. Regulation 6 talks about the time of publication of the Form A. It doesn't give the timeline for filing claims. So that is in regulation. Last part, it says the last date for submission of proof of claim shall be 14 days from the date of appointment of the IRP. Here you need to note down, it is not 14 days from the insolvency commencement date. It is 14 days from the date of appointment of IRP. Earlier, this provision was contained in the code. Later on, because of some judicial pronouncement, it was removed from the code and put in under the regulations. So the timeline as per the public announcement is 14 days. And if still it can't be done in 14 days, then regulation 12.2 says that it can be done within 90 days. So that regulation has also kept on changing. Earlier, it was there that if the creditor is not able to file the claim within the statutory period of 14 days, he can file it any time till the resolution plan is approved. Again, it was changed to reduce it to 90 days. And now there has been again a change in the regulations regarding the timeline for submission of the claims. This is the revised regulation, which has been done recently with effect from 18th September 2023. And it reads like, a creditor who fails to submit claim with proof within the time stipulated may submit his claim with the proof to the IRP or RP up to the date of issue of request of resolution plan under regulation 36B. And the timeline given there is 105 days from the insolvency commencement date. The second limit is 90 days from the insolvency commencement date, whichever is later. So either within 90 days or within 105 days, the creditor can submit a belated claim. But if it is beyond 90 days, then the creditor shall provide reasons for delay beyond 90 days. So it is slightly a glitch in the drafting in the sense, beyond 90 days or 105 days, if somebody is filing a claim, then it should give a reason, because otherwise here, by virtue of this clause, submission of claim up to 105 days is also allowed. So this is now the latest position in terms of the regulations for the timelines for submission of the claims. Now see what happens if the claim is submitted beyond 90 days or beyond 105 days. So here again, the responsibility of IP has been enhanced drastically. What it says is that if the claims are received beyond the timeline of 90 days or 105 days, the RP shall verify the claims and classify them into two categories, acceptable or non-acceptable. If it is non-acceptable, then communication to the creditor within 7 days. But what happens if it is acceptable? So again, there are two options or line of actions given for the insolvency professional. In case of non-acceptable claims, it is straight communication to the creditors that it is not acceptable. Let him take recourse to the judicial remedy by filing an application before the adjudicating authority under section 60, subsection 5. The second situation where the RP finds that the claim is acceptable, then the claims are to be put up before the next COC meeting for its recommendation for inclusion in the list of creditors and its treatment in the resolution plan. And the next step is to submit before the adjudicating authority for condonation of delay and adjudication wherever possible. So here the role or the responsibility has increased multifold. Like whenever there is a claim, within 7 days he has to verify it and classify it as whether acceptable or not. Then he has to take it to the next COC meeting and then file an application before the adjudicating authority on behalf of all such creditors. Now imagine he has done this process. After that, again, there are some claims. So he is duty bound to put it before the next COC meeting and again to take it before the adjudicating authority. So this change in the regulations, instead of simplifying the process or making it easier for the insolvency professional, this is bound to create more hassles and the litigation for the insolvency professionals. The claims once filed can also be updated by the creditors. There is the need of filing an updated status of claims in case it is satisfied partly or fully from any source in any manner. Now, when we say there is a and no claim as on insolvency commencement date can be paid to any of the creditors. So where is the issue? How can a creditor get the payment for this? What is the possibility? It could be in a situation where there is a guarantor, individual or corporate guarantor, and the claim is made to such guarantors, and there is some money received out of that. In that case, there will be a need to revise the claims or update the claims, reduced to the extent amount has already been received. Now, we will discuss a few case laws related to the timelines. Some of that has become irrelevant because there is a modification in the regulations. So this is the first pronouncement of NCLT with reference to the timelines when the regulations prescribe, when the code prescribed the timeline of 14 days and the regulations in prescribe that it can be submitted anytime till the resolution plan is approved. So it was a very vague type of provision and it kept the claim submission process open till the resolution plan was approved by the committee of creditors. So here the observation or the decision or the order of the adjudicating authority was that this regulation comes in direct conflict with the provisions of the parliamentary statute, with the provisions of section 15, subsection 1 of the IBC. We do not think that by subordinate legislation, the timeline provided by IBC could be eroded in such a manner as to cause delay. So after this judgment, this section 15(1) was amended and the timeline of 14 days was removed from code and it was put in the regulations. Same principal bench, after some period of time, changed its opinion and it said that since regulation 12(2) prescribes the last date till submission of the resolution plan, so the claims can be submitted till then. So like that, there were a lot of cases coming to NCLT for condoning the delay in filing the claims, and perturbed by all those cases, principal bench made a judgment in this 21st century case it says resolution plan is under consideration of the COC. Therefore, there is still time for the consideration of the claims as the CRP is not yet over. Accordingly, we direct the RP to consider the claims without rejecting on the grounds of delay. So the only ground which was restricted for rejecting a claims was delay. If otherwise the documents are not sufficient or they are not able to prove the claim, then it can be not considered. But solely on the ground of delay, the RP should not reject a claim. Then in Adelweiss case, the Honorable NCLT passed a general direction. We wish to make it clear that all RPs shall make a note of these repeated orders passed by NCLT, clarifying that the claim of an applicant like the present one could not be rejected on the ground of delay as the provision has been held to be directory. So the provision in Regulation 12 Sub-Regulation 2 putting the 90 days limit has been considered as directory, and that's why it passed a general order that the RPs should accept the claims even submitted after 90 days. Over a period of time, this situation has also changed. NCLT Ahmedabad in Harris Polymer case rejected the idea of getting the claim beyond 90 days. And it put strictly the limit. If such a practice is allowed, keeping abeyance the stipulated period, that too after extended time period of 90 days, in that event, it would be difficult to complete the CRP process, which has to be completed in a time-bound manner. So this is the first time any bench of NCLT insisted on submission of claims within the prescribed period of 90 days. The matter was in appeal before Honorable NCLT, NCLET, and the NCLET also approved the order of adjudicating authority. And it observed that the regions recorded for AA have substance, and if at belated stage, when the resolution applicants are already before the COC with their resolution plan, if a new claim keep popping up and are entertained, the CRP process will be jeopardized, and the resolution process may become more difficult. The applicant was not satisfied with this. They approached the Honorable Supreme Court. So Supreme Court also did not interfere. And the brief order of the Supreme Court was that we find no reason to interfere in the order dated 18th June 2021 passed by the National Company Law Appellate Tribunal. So for this judgment of the Supreme Court, it was clearly established that the RP is within the right not to accept claim submitted beyond 90 days after the insolvency commencement date. There was one case of the regional PF commissioner filing the claim as late as 936 days. So that was also rejected by NCLET, saying that this kind of indulgence is not expected from a government organization. So that was the situation of claims received before the resolution plan. And here the situation has been oscillating with reference to the regulations as well as with reference to the judgments of various benches of NCLT. Now, after the approval of the resolution plan, Honorable Supreme Court has categorically mentioned, it has propounded the theory of clean slate in Ghanshyam Das case, where it said that if the claims keep popping even after the resolution plan is approved, the idea or the soul or the basic purpose of IBC will be defeated. So in several judgments, the claims submitted after the approval of resolution plan have been rejected. The first case was of Tata Steel, where after it has took over the corporate debtor under a successful resolution plan, the claims or suits were filed, and High Court allowed such suits. So Supreme Court put a stay on the recovery suits filed against the Bhushan Steel, which was taken over by Tata Steel. Same thing was held in COC, or in the case of COC of SR Steel. The Supreme Court observed that for fear of fresh claims coming up, resolution applicants may not be willing to submit the resolution plans. So this was to protect the successful resolution applicants from future developments or future claims being coming in. This was the final seal or final stamp put by the Honorable Supreme Court. That was in Ghanshyam Mishra's case. Supreme Court held that the legislative intent of making the resolution plan binding on all the stakeholders is that after the approval of the resolution plan, no surprise claims should be flung on the successful resolution applicant. It should start with fresh slate based on the resolution plan approved. So the liability of the successful resolution applicant will be only to the extent of amounts mentioned in the approved resolution plan. Any claim which was not submitted or any claim which comes after the approval of the resolution plan will not be the liability of the successful resolution applicant. And the Supreme Court went on to the extent that on the date of approval of resolution plan by the adjudicating authority, all such claims which are not a part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect of a claim which is not part of the resolution plan. So we have discussed the two situations, timelines for the claims or the acceptability of the claims before resolution plan is approved and after the resolution plan is approved. Now, another element is in terms of applicability of the law of limitation. Initially, Honorable Enclett held that the law of limitation will not be applicable to IBC. And if at all it is applicable, it will be applicable from 1st December 2016 when IBC was notified. So the first limitation will be only after 1st December 2019. And this created a lot of problems with the corporate sector because all of a sudden, all those claims which were dead as per the law of limitation, they could invoke the provisions of IBC. And that's why Section 238A was added, making the law of limitation applicable to the proceedings under IBC. Then the question was whether the law of limitation will be applicable from the date of amendment or earlier. The Supreme Court in BK educational case held that since this is a clarificatory provision, it will be considered to be applicable from the date of commencement of IBC, that is 1st December 2016. This is the provision, Section 238, and this Supreme Court held in BK educational case that the law of limitation is applicable to IBC since its inception, though the amendment was made effective by the Parliament with from 6 June 2018. So one thing is very clear, the law of limitation is applicable to proceedings under IBC since the date of its notification. Now the question is whether RP can apply this law of limitation for accepting or rejecting the claims. Generally speaking, it is yes, because if the RP accepts a time-barred claim, this will unnecessarily burden the financial responsibility of the successful resolution applicant. When the legal right is already closed, can it be revived? And that's what was also part of the Insolvency Law Committee recommendations. But the problem is with the reference to the judgment of Honorable Supreme Court with regard to the role or duties of the insolvency professional. And it has clearly contrasted with the liquidator, saying the liquidator has a right to admit or reject, but the RP doesn't have a right to admit or reject. So from that angle, it looks like that RP cannot adjudicate whether a particular claim is within the limitation or not. But prima facie, he can make an opinion and can communicate to the creditor that given the documents or given the details provided, it looks like that the claim is time barred and he is not collating that in the list of creditors to that extent. So let the creditor approach adjudicating authority under section 60 subsection 5 and take an appropriate order. Recently, there has been a disciplinary case against the insolvency professional where he admitted the time barred claims. And then his registrations was suspended for 2 years. But the facts there were slightly different in the sense an order of the adjudicating authority was already available deciding that the claim is time barred. This was the case. This was one of the cases where one of the financial creditor objected to acceptance of a claim which was barred by limitation. So here the issue was taken before the adjudicating authority and the appellate authority by another financial creditor. Adjudicating authority has rejected the claim on the ground that other financial creditor has no right to intervene in such type of things. But then NCLET set aside the order of adjudicated and directed it to consider it on merits, whether the claim is within the limitation as prescribed under law of limitation or not. So as I referred to you that Insolvency Law Committee, which has triggered addition of section 238 in the code, it also covered the situation for the claims, not only for initiation of section 7 application. So what the Insolvency Law Committee observed was when an application under section 7 cannot be entertained for a debt, that is after section 238A was added and the Supreme Court held that this will be applicable since notification of IBC, which is barred by the time and is liable to be rejected. Any addition in the claim which may fall into the category of time barred debts also cannot be entertained. So that gives some strength to the verification process of the claims by IRP or RP that if there is a time barred claim, he is not bound to accept it. And he can communicate that these claims are barred by limitations, so he will not be able to accept it. This was the disciplinary case against an insolvency professional. Here the situation was different in the sense the financial creditor had approached to initiate insolvency process against the corporate debtor, but his claim was found to be barred by limitation, so NCLAT rejected the application. But later on, another financial creditor filed section 7 application and the CRP process started against the same CD. And when the CRP process started, that earlier financial creditor submitted a claim which was admitted by the IRP based on the legal opinion taken by him. So now it's a very typical situation. Here already there is a judgment of NCLAT available which says that the claim is time barred. Still, the resolution professional accepted it based on an opinion taken from an advocate. And what was the opinion? One of the paragraphs in that order which rejected the CRP application filed by the earlier financial creditor was, any observation made in this order shall not be construed as an expression of opinion on the merits of the controversy and the rights of the petitioner before any other forum. So that was misinterpreted by the legal counsel, saying that the limited purpose for which this claim has been held as time barred is only for the application before NCLT. All other forums are independent to take their own decision. And that's the reason he accepted the claim which was taken against the decision of the NCLT. Therefore, on this IBBI suspended the registration of the IP for a period of 2 years. Of course, there were other non-compliances by the RP apart from this non-compliance. So one thing is clear here, that as far as the time-barred claims are concerned, the IP has to be very, very careful. If there is already a judgment or order holding it to be a time-barred, he can straightway deny collating the claim of such creditors. Wherever there is no order, because RP is not a adjudicating authority, he can simply say that based on the document submitted, it looks that the claim is time barred, so he will not be in a position to accept the claim. So based on that judgment or the decision, the creditor can approach the adjudicating authority for adjudication. And if the adjudicating authority admits the claims, then he can admit the claim, otherwise not necessary. So that, just to summarize, that in terms of timelines, the role of RP in accepting or rejecting a claim is timelines as given in the public notice, timelines as given the regulations, timelines as per the law of limitation. Like you have seen in the case of ARC, where one financial creditor objected to the claim filed by another financial creditor. So the issue was whether there is a locus of a creditor to object to claim acceptance of another creditor, because this duty is cast on the insolvency professional, not on the committee of creditors. So in this case, there was an home buyer who filed an application objecting to the claim of another financial creditor. So Honorable NCLT approved, I think it was the NCLET, he said that the right of financial creditor to object another a claim by another financial creditor is there. It can't be compromised. And it was based on judgment of Honorable Supreme Court in Phoenix ARC case, where it was held that financial creditors forming part of the COC must be heard during the proceedings which would establish the status of other financial creditor. The reason for this type of observation or decision is that if the claim of a creditor is accepted, it will have the impact on the voting share of the existing financial creditors. So maybe for that purpose, giving it an opportunity of being heard, this right was established by the Supreme Court. Tulsianji, any query related to this timelines or this, if it is to be addressed before we go further?
Sir, we have query, but I think we should put on the last.
Okay. Deliberation. I thought that sometimes there are issues which people want to clarify immediately and they are not able to proceed further. So in that case, we can take up. So the judgment of Honorable NCLT. Yes.
Can you put us some query?
Your voice is not audible.
Can you put us some query, sir?
Yeah, if related to these timelines, you can put up so that the monotony is broken.
There are 3 to 4 questions received from the claimant, from the participant. What is that? Whether RP ultimately has the power to reject or not?
Based on the judgment of Honorable Supreme Court in Swiss Ribbon, it is very clear the RP does not have any power to reject a claim because his role is to collate. So what we do, there is another responsibility of RP is to determination of the claims based on the documents submitted. So that is the process of verification. So RP can do the verification and communicate that based on the documents, the claim to the extent of so much amount is acceptable. He may not use the word reject. And he can communicate that out of, say, total of 100, the claim is accepted for 80, 60, 40, depending on the facts of the particular case.
Second question that is received is with respect to public announcement. It is said that within 3 days of appointment of IRP, there should be public announcement. The question is that, sir, the order was reserved by the Honorable NCLT, and it was pronounced after 2 days. And after the pronouncement, IRP was completed after 2 days. So which date should be taken at the appointment of IRP?
See, the date of communication to the insolvency professional will become the base for counting these 3 days. Because unless it is communicated to the insolvency professional, the order was reserved. So or that day we don't know whether it will be accepted or rejected. So it is only when the order is pronounced and communicated. There may be a situation when the RP is present when the hearings are there, when the order is pronounced. So technically, the RP is aware of his appointment. But the problem is that unless he has that order, signed order in hand, he cannot initiate the process, because at times the newspaper also asks for the order when you are giving the Form A for publication. So it will be in the interest of the RP that unless he has that order, either uploaded on the website of NCLT or given to him, he should not initiate the process. And the period of 3 days will be counted from the date of order. Nowadays, when you see the NCLT site, it also indicates when the order was published. So you have a definitive proof as to when the order was published.
Sir, one more consequential question is that, suppose if we take the date of communication to the IRP as a appointment date, in that situation, Form A, the publication, the date of order is asked. So what's written there?
Can you please repeat? Your voice is echoing.
When you go for publication, sir, so the one column is asking the date of pronouncement of order and date of appointment of IRP. So which date should be given there?
See, date of order should be the date of pronouncement.
Okay.
But the 3 days will be counted from the day when it was communicated to the insolvency professional.
Okay. Okay. Thank you.
And again, people should observe that the 14 days timeline is from the date of appointment of the IRP. And 90 days time is from the date of insolvency commencement. So insolvency commencement is the date of the order of NCLT, and for this 14 days is from the date of communication to the IRP.
Great. Sir, one more question received from a participant. What an IRP will do if no claim is filed by the financial creditors within due time, even after reminder?
I couldn't hear you clearly.
Sir, if the financial creditors doesn't file its claim within due date, and IRP also reminded them for filing the claim within due date, but they have not filed the claim till now, then what IRP should do?
What IRP can do? He can only request for filing the claim. He can't force anybody to file a claim. And unless he files the claim, he will not have any right in the committee of creditors.
Then there no COT will be formed in that case.
Yes, we will come to such situation. He has to approach the adjudicating authority for appropriate orders.
Okay. This question I received, sir, and later on, when you receive the question, we will ask.
Okay. So, very interesting situation came up regarding disclosure of the names. One of the requirement after verification is that the insolvency professional will keep the list of creditors in the office. And now there is an amendment which says that it has to be uploaded on the portal of IBBI so that public at large know what are the claims which have been collated by the insolvency professional. And there is a requirement in Regulation 13 which says that if there is a website of the corporate debtor, it should be displayed on the website of the corporate debtor. So this was one of the earlier cases, this JP case, where the RP did not display the list, and he took the shelter of Article 21 of the Constitution, which says the right to privacy. The issue in this case was that the name of some of the prominent persons were similar to the name of list of creditors, and they might be wanting that such lists should not be made public. But given the responsibility under Regulation 13, it is the duty of the RP to keep this list in a very transparent manner. And now it is uploaded on the website of IBBI also. So the order of the NCLT was the object of directing the IRP to publish the list of creditors containing names of the creditors along with the amount claimed by them is to maintain transparency in respect of their claims and to determine their voting share. So therefore, such an information must be made available not only to the members of the COC and other creditors who are not members of the COC and the whole world. So the idea of protecting privacy of the creditors was rejected in view of the provisions contained in regulation. There could be a situation like one you raised, the financial creditor who initiated the CRP process did not file the application. In some of the cases, such creditors say that since the CRP has been initiated based on our application, whatever is the amount mentioned in the application should be taken as the claim of the creditor. So this idea was also rejected because it's a summary adjudication by the NCLT. What they see, whether there was a debt, whether there was a default to that debt, and whether the default was rupees 1 lakh or more that time. Now the limit is increased to 1 crore. So these are the three things which the adjudicating authority look, apart from whether the name of the person who has been appointed or suggested as IRP is not subject to any disciplinary proceedings. So Honorable NCLT held that application has to be filed, the claim has to be filed even by the person who has initiated the CRP process. The RP is not supposed to take the claim amount from the petition for CRP. So in the petition, the amount is not ascertained. They just see whether the amount claimed is more than the threshold limit to trigger CRP process. So actual quantification is to be done by the IRP or RP when the claim is filed. And there have been many cases where the applicants submitted the claims, it was found not to be sustainable. They might have claimed huge amount of interest, which was not actually payable. So the IRP will not admit the amount of interest. So the lesson from this is that any creditor has to file a claim. The RP cannot consider without submission of the claim, even if it is in the books of account, even if it is in the application filed for initiating the corporate insolvency resolution process. Similarly, NCLT also held that it's not a recovery proceeding where the adjudicating authority will decide the amount of claim, and therefore the claim has to be submitted by the creditor, without which the RP cannot proceed further. This is the most important part and the most litigation-prone aspect. Whether a creditor is a financial creditor or operational creditor, because the privileges of financial creditors are more than that of the operational creditors, unless the COC committee is constituted of the operational creditors, because the voting right is only with the financial creditors. So often there is a dispute as to whether a creditor is financial creditor or operational creditor. In brief, I'll just explain the difference. Operational creditor has been defined to include the creditors who provides goods and services, or the employees and workers. And the fourth category is the dues of the government. So it includes the dues of central government, state government, and the local government. There are four categories which are considered the operational creditors: suppliers of goods, supplier of services, employees and workmen, and the government dues. But the definition of financial creditor has been put in like an inclusive. There's a long list of creditors considered as financial creditor. But the essence of the concept of financial creditor is time value of money. It has to indicate time value of money, even whether the loan given without the interest was also considered as a financial creditor. So what is more important is time value of money, not the interest. There could be some loan without interest. There could be loan with interest. So that will not make difference as far as the category of operational or financial creditor is concerned. Now, this is the first case, very important case and famous case, Anuj Jain, IRP of JP Infratech versus Axis Bank Limited. This also exposes the way banks are lending money. Normally, what they will do, they will take the corporate guarantee or the backing of the security of the assets of another company. So in this case, what has happened? JP Associates Limited took a loan from Axis Bank, and as a security for that loan, assets of JP Industries Limited was mortgaged, and JP Industries Limited was under insolvency. So the Axis Bank filed a claim as a financial creditor in JIL, which was rejected by the insolvency professional, saying that it is not a financial creditor of the corporate debtor, which is subsidiary of the holding company, because the loan was given to the holding company. So here, Honorable Supreme Court has analyzed this in detail and came to the conclusion that since the loan is given to the parent company on the security of the assets owned by the subsidiary company, he cannot be considered as a financial creditor of the subsidiary company. He could be a secured creditor because there is a mortgage in his favor, but he can't be considered as financial creditor. And unless he is considered as a financial creditor, he cannot become a member of the COC. And it observed that mortgage being neither toward any loan facility or advance to the corporate debtor, nor towards protecting any facility or security of the corporate debtor, do not constitute a financial debt within the meaning of Section 5, subsection 8. So they could be on the strength of the mortgage's secured creditor. And the secured creditor doesn't have any say in the committee of creditors. There's no voting right assigned to it. It is only to the financial creditor, whether secured or unsecured. Similar judgment of Honorable Supreme Court in Phoenix ARC, where the shares of a corporate debtor were pledged for the loan granted to the holding company. So again, using the same argument, Honorable Supreme Court has held that such a creditor can be considered as a secured creditor on the collateral of the security, but it can't be considered as a financial creditor because the loan has not flowed to the corporate debtor. It has flowed to the parent company. So we have seen two situations where the loan security was on the basis of mortgage of assets and pledging of shares. In both the case, the lender will not get a right as a financial creditor. Had it been a situation that the shares of the company are placed or the assets of the same company are placed, then they will be in the shoes as a financial creditor. I hope that is clear. Now, another situation, normally it is in case of real estate matters, where the landowner enters into a development agreement with the corporate debtor. So landowner is not in the capacity of a creditor. He is like a promoter or an owner of the project. So in this case, the owner of the land filed the claim with the RP and RP accepted it as a financial creditor. Some of the home buyers filed an application taking an objection, and the adjudicating authority allowed the plea for removal of the landowner from the COC. In the appeal, NCLAT also upheld the decision of adjudicating authority that the co-promoter cannot become a creditor. He cannot become a financial creditor. No amount was disbursed for the time value of money. The landowner cannot be regarded as a financial creditor within the meaning of Section 5, subsection 8, which defines the financial creditor. So NCLAT upheld the order of adjudicating authority, and it is based on the earlier judgment of NCLAT, where the similar issue was decided, and the promoters or the providers of the land were not considered as the financial creditors. Another interesting situation is that the loans which are not bearing any interest, can it be considered as a financial creditor? So in two cases, Honorable NCLAT has analyzed the situation and the impact of such loans and found that there was an element of time value of money, and held that such loans from the promoters and directors to the company for improving its financial position are in the nature of financial creditor, and the time value of money element is satisfied. The amount disbursed as a debt against the consideration of time value of money may or may not be interest bearing. Even if you see the definition of financial creditor in Section 5, subsection 8, it is clear that the interest element is not compulsory. It may be, it may not be. So the justification was that enhancement of assets, increase in production, and the growth in profits, share value of the equity ensures to the benefit of such shareholders, and that is the time value of money, constituting the consideration for disbursement of such amount raised as the debt with obligation on the part of company to discharge the same. So they satisfy the criteria of financial creditor. Similarly, in the Microsoft Tech also, it was upheld that the loans given by the promoters will be within the definition of financial creditor. But now the question is, they can be considered as a financial creditor, but whether they'll be able to participate in the meetings of the COC as a financial creditor, the answer is no, because one of the requirements for the members to be for the members in FC is that COC, that they should not be related parties of the corporate debtor. So though they satisfy the criteria of becoming financial creditor, they do not satisfy the criteria of becoming members of the COC as financial creditors. But there is another provision which talks about the directors or the members of the suspended board of the directors are to be invited in the meetings of the COC as participants. They don't have any voting right. They don't have any voting power. They don't have any right to speak unless the chairperson, that is the RP, allows them. So by virtue of the provision that the directors are entitled to participate or observe the meetings of the COC, they can be in the COC meetings. But they can't be by virtue of their being financial creditors, because the directors are a related party of the corporator, and hence they are disqualified from becoming members of the COC. This is an order or judgment regarding operational creditors. So far, we have discussed all the judgments regarding financial creditor. So here, NCLET clarified that the statutory dues such as income tax, sales tax, value-added tax, and various other taxes fall within the definition of operational debt. So we had seen 4 categories. This is an explanation of the last category, government dues. The earlier categories are suppliers of goods and services, employers, and workmen. So this is regarding the classification as operational creditors and financial creditor. Another question you may face is that the decree of a civil court will amount to financial creditor or operational creditor. So here there is a judgment of NCLT which says that the decree of a civil court will not alter the basic nature of the transaction. The transaction prima facie has to be considered for the purpose of adjudicating a claim. So like if the decree was obtained by an operational creditor, then it will be treated as operational creditor. And if the decree was obtained by a financial creditor, it will be considered as a financial creditor. So the underlying transaction will decide whether the decree holder will be an operational creditor or a financial creditor. It can't be that the operational creditor, after obtaining the decree, claims the status of financial creditor. Claims of beneficial owners in case of pledged share. So what happens in case of pledge? Like we have seen, the security on of shares and the financial creditors gave loan. So this is not regarding the status of the creditor, whether financial or operational. This is regarding the amount of claim. Let's take an example. If there is a loan of, say, 1,000 crore and the shares worth 200 crores have been pledged as a security against that loan. So what will be the amount of claim? 1,000 crore or 800 crore? Because he is enjoying the security of shares to the extent of 200 crores. So this was in the case of Jet Airways. The RP first accepted the claim of the financial creditor to the extent of rupees 956 crore, and it was reflected in the list of creditors. Thereafter, the RP amended the amount of the claim and reduced it by 200 crores, and that was to the extent of the value of the shares which have been placed. So the contention of RP was that since the pledge has been invoked and the financial creditor has got his name added as a beneficial owner in the demat account for the amount of this shares valuing 202 crores, so he reduced the claim to that extent. So the aggrieved financial creditor approached the adjudicating authority and then the NCLET. And NCLET held, again based on one of the judgment of Honorable Supreme Court, that in case of pledge, the ownership is not transferred. And unless the ownership is transferred, you can't reduce the amount of claim. This is the judgment. It says the RP had incorrectly reduced the financial creditors admitted claim and directed the successful resolution applicant to bear the liability of the paying additional amount to FC from the amount reserved under resolution plan. So it so happened that in the meantime, resolution plan was also approved, and with the reduced liability of that financial creditor. So this was based on Honorable Supreme Court's judgment, which analyzed and clarified the right of a pawnee when he has pledge of the security. So it said that it has to be held that registration of the pawn, that is the dematerialized share, in favor of the PIFSL as a beneficial owner does not have the effect of sale of shares by the pawnee. The pledge has not been discharged or satisfied either in full or in part. Just by adding the name as a beneficial owner, the claim has not been discharged. It will be only when there is a sale and the sale proceeds are applied towards the claim. So based on that, it was held that where there is a pledge, you can't reduce the amount of claim to the extent of the security which has been pledged. So PISL is not required to account for any sale proceeds which are to be applied to the debt on the actual sale. The two options under Section 176 of the Contract Act remain and are not exhausted. So this is because of the stage of realization of the security that you can't reduce the claim. Now, whether penal interest can form part of the admitted claims or not. There is no specific provision either in the code or in the regulation, but in the form for claim, it is mentioned that any other interest. So from that, it is taken that even the penal interest can be added into the claim. But the question is whether you can charge interest on the penal interest. So the answer is no. Again, that is based on a Supreme Court judgment which says that penal interest is a special kind of interest. It is for one-time event. There is a default, and you can't capitalize and add it to your principal or other unpaid interest. You can't charge interest on a penal interest. Depending on the covenants of a contract, you can charge interest on interest. Suppose the interest is due for a year and it is not paid, and as per the covenant, if that interest is added to the principal and then you can charge interest on it, it's perfectly right. But when there is a provision of penal interest, the penal interest, even if it is not paid, it can't be added to the principal amount and unpaid interest to further charge interest on it. So this is the provision, like there's no specific provision, but Form C in row 4 says that submission of proof of claims. Here the total amount of the claim, including any interest at the insolvency commencement date. So the word any would include penal interest. And regarding the liability of charging interest on penal interest, Honorable Supreme Court has held that penal interest has to be distinguished from the normal interest. Penal interest is an extraordinary liability incurred by a debtor on account of his being a wrongdoer for not making the payment. So penal interest can be charged only once for one period of default and therefore cannot be permitted to be capitalized. Capitalized means you can't charge interest on it again. So this is the position regarding charging of penal interest. Now, in case of disputed claims, what will the RP do? By virtue of Section 14, all the proceedings will be stayed if it is against the corporate debtor or it's against the assets of the corporate debtor. But if there is any proceeding which is beneficial for the corporate debtor, it can continue. The arbitration can also continue, which is in favor of the corporate debtor or which is filed by the corporate debtor. So what the RP should do when there is a disputed claim? What amount it should put as the claim. So we have a reference judgment of SR Steel, where the RP took a token value of ₹1 because he has to collect the claims. He collected the claims, and since the matter was sub judice, the amount could not be decided unless the matter was decided. So in that case, the RP put a token value of ₹1. This is mostly in case of operational creditors, where the voting right is not in the issue. And Honorable NCLT upheld this. And the matter was even before NCLAT and the Honorable Supreme Court. None of them objected to this practice of taking a token amount of ₹1. In fact, they confirmed this in absence of any identified amount of the claim. So the observation of an Honorable NCLT was that RP is required to include their name in the list of creditors, which will be subject to the final outcome of such dispute. So by these applications, the applicant commonly felt aggrieved with the decision of RP rejecting their respective claims filed by the OCs and by partly admitting only notional value of ₹1. Therefore, this IAS can partially succeed only to the extent of direction may be issued to the RP to register their respective claims and update the list of claims to the token amount. So this was upheld even in the Supreme Court, that RP can take a token value just to include those claims in the list of creditors. Another similar situation, what the RP should do in case these documents are not adequately stamped. What is the impact? Inadequately stamped documents are not admissible as evidence. But there is a provision that the required stamp duty with the penalty can be paid, and then those documents will be admissible. So what the RP should do? We have here different opinions from two benches of NCLT, and then we'll see the discussion or decision of NCLT, which will be binding now on all the benches. So in Paragon Steel case, it was held that it is a financial contract, loan agreement, and not mere a receipt for amount paid to the corporate debtor. It was not stamped. It was a MOU. And in the instance case, since there is no other financial contract evidencing the pledging of securities, the MOU is to be treated as an agreement, which is to be text in the terms of the Stamp Act. The applicant was directed to fulfill the requirement under the Stamp Act so that MOU may be accepted as a valid. So that was a very supportive judgment, that you can pay the liability of stamp duty, and then this document can be considered as a supporting document for the claim. But in another case, NCLT Ahmedabad rejected this idea. They said, in our view, the RP cannot be found fault with due to non-admission of such claims of the applicant for want of proper stamp duty. The question whether has been properly stamped or otherwise can only be looked into by the RP or the competent authority for registering the claims. Hence, in our view, this can be adjudicated only by a competent civil court having necessary jurisdiction, and the adjudicating authority cannot be expected to deal with the relevant provisions of Indian Stamp Act or to make a declaration about the documents in question are properly stamped or otherwise, because it is a subject matter of the scrutiny by the officers of the collector of stamp, and it is in the domain of the competent civil court. So two benches having different opinion, one saying, okay, the non-compliance can be regularized by paying the stamp duty now, and the other saying that the action of RP is all right. He can't accept an improperly stamped document. But then now there is a judgment of Honorable Anklet which says when the agreement is executed between the parties, signed by the both parties and acted upon, and mere fact that it has not been engrossed on stamp papers shall have no adverse consequences on the claim of operational creditors. So here, as a matter of abundant precaution, what the RP can say that you get these documents adequately stamped and may keep that claim pending till it is done. Another situation could be whether a claim can be filed against a guarantor as well as the principal debtor, or when there are multiple guarantors, whether it can be filed against those guarantors or not. Since claim is not the amount which has been actually received, it is only a claim and it is unpaid. It remains unpaid and it is not certain whether in the insolvency resolution he'll get the full amount of the claim from the principal debtor or the corporate debtor or not. So here, the creditor is allowed to file a claim against the debtor as well as the guarantor. And if there are multiple guarantors, against each one of them. So if there is a, say, claim of 10 crores, then he can file the claims for 30 crores, 10 crores against each of the debtor, or if there are two guarantors, then 10 crores each against the guarantor. But as we have seen regulation 12A, which says that the creditor has to update his claim based on the amount received. So if he receives any amount from any of the guarantor or the principal debtor, then he has to reduce his claim. In total, he cannot get more than 10 crores, but he can make claims against each of the guarantor and the principal debtor. And this is called the principle of double dip and double dividend. He can have double dip, like he can make claims against all these people responsible for making payment, but he can't claim dividend more. In that case, the total dividend cannot exceed 10 crores, but his claims can exceed 10 crores. He can't have double dividend, but he can have double dip. So this is the observation. CRP was going against the principal debtor as well as the guarantor. The bank filed its claim with the RP of the principal as well as the guarantor. RP of the guarantor rejected the claim that since the same has already been admitted by the RP of principal debtor, such claim, then the recovery amount may exceed the total claimed amount. But then NCLT held that he can make the claims to both of them, because the definition of financial debt, RP is not allowed to raise objection contrary to the provisions of the guarantee agreement. Because liability is there of the guarantor as well to the extent of the loan if it is not paid by the principal borrower. In another case, Anklet also held that till payment is received in the CRP process, the claim of the lender for the same amount can be maintained in the insolvency proceeding against both the principal borrower as well as the corporate guarantor. And in case there are more than one, then against each of the corporate guarantor, he can claim the total amount. But the moment he receives any amount, then it has to be reduced from the claim with the other persons who are liable to pay. Now, another dimension of the guarantee. This is the guarantee for a loan. In case the guarantee is not invoked before the corporate insolvency resolution process, by virtue of moratorium under Section 14, it cannot be invoked. And no claim can be made for uninvoked guarantees. If the guarantee has been invoked before insolvency commencement, there can be a claim made. After insolvency commencement, by virtue of Section 14, guarantee cannot be invoked. There is an exception, of course, of the performance guarantee, which can be invoked. And if the performance guarantee is invoked, a claim can be made to that extent. For uninvoked guarantees, no claim can be made. So this is the latest judgment. Initially, NCLET was having a different view. NCLET said, since this is a right of payment, even uninvoked guarantees, a claim can be filed. But now the position has been settled because of the judgment of Honorable Supreme Court in Ghanshyam Mishra's case, that there cannot be any claim for uninvoked corporate guarantees. And guarantees cannot be invoked after commencement of the insolvency. So in this case of IDBI trusteeship, the NCLET has also changed its position based on the Supreme Court judgment in Ghanshyam Mishra, and it said that CD is a guarantor, and when the corporate guarantee has never been invoked prior to the commencement of the CRP, as on the date of filing of the claim, the right to payment has not yet accrued. And if we similar in the Supreme Court, another judgment. This was the old judgment of NCLET, which says, of course, it is now irrelevant. It is just for academic discussion, that how the situations keep on changing based on the judicial pronouncements. And IP, being an officer of the court, is to abide by this type of judgments. So here it says, can file its claim irrespective of the fact whether the same is matured or not at the time of commencement of the CRP. So now this judgment is not relevant in view of the Honorable Supreme Court's judgment in Ghanshyam Mishra's case. Uninvoked guarantee, no claim can be made. And after insolvency commencement, no guarantee can be invoked with the exception of performance guarantee. तुलसियान जी, जब भी क्वेश्चंस स्टार्ट करने हो आप मुझे बता देना. Till then I'll continue.
Okay, sir.
You want to start? Or we can take?
After 5 minutes, sir.
Okay, we can take another situation, whether RP can revise an admitted claim. If we see Regulation 12A, it says the creditor can revise the claim. So RP has to revise the claim. Similarly, there could be additional documents coming to the knowledge of RP. In that case, RP is entitled to revise the claim. But there has been one case where the RP tried to change the status of a creditor from financial creditor to operational creditor. So there, the Honorable NCLET has given a judgment objecting to this type of approach of the RP. He said, RP is within the rights to revise the claims based on additional information or documents submitted, but the RP cannot change the status of a creditor from financial creditor to operational creditor and vice versa. That is not in the domain of the powers of RP. There, then he has to approach the adjudicating authority. This was in the Intech Capital case. Post-admission of Section 7 application, the claim of 6.52 crore was admitted. And thereafter, the RP came to know that the financial creditor has also initiated arbitration. So that means that was a disputed amount. So to that extent, RP has reduced the claim to 3 crore 16 lakh. And this was upheld by the adjudicating authority and also by NCLAT. So the NCLAT said that while upholding the order of adjudicating authority, observed that in terms of regulation 14.2 of the CRP regulations, RP has right to revise the amounts of the claim admitted as and when he comes across any additional information warranting such revision. But the reverse of that is where the status of an financial creditor was changed to operational creditors. This was rejected by NCLAT in Rajneesh Jain versus Manoj Kumar Singh case. Again, RP may add to the existing claims of the claimants already received or admit or reject further claims and update the list of creditors. But after categorization of a claim by the IRP or RP, he cannot change the status of a creditor. Here, first he admitted as a financial creditor and then he changed it as operational creditor. So that is not allowed.
Sir, can you take up the question?
Yeah, just one more dimension.
Okay.
Whether RP can file an appeal against an order of adjudicating authority regarding admission or rejection of a claim. So here again, NCLT said that RP is not a party which is affected by the such decisions. So RP should go by the decision of the adjudicating authority. RP should not file an appeal against the determination of claim by the adjudicating authority. So here, RP went to file an appeal against the order of adjudicating authority admitting a particular claim. So that was avoided. So RP should be careful. RP should not go against the decision of the adjudicating authority in appeals. He should go by the decision. Yes, Tulsianji, now we can take up. We have around 15-20 minutes. Only one request. Your voice is echoing, so I'm not able to understand the question. So you can have the mic for a clarity of voice. Should I stop this?
I tried to be louder, sir.
Okay.
Sir, first question is that once before reserved for order by the NCLT, a claim was filed. The claim was already rejected by the IRP due to delay. And in the meantime, the financial creditors didn't file the fresh claim even after the conversion. So what the IRP do? What the IRP do?
I'll again request you to repeat the question. What I understood is that first the claim was filed and it was rejected by the IRP.
Yes. Yes, sir.
And then he again filed the claim.
Then he approached to the NCLT for conversion of delay.
Okay.
He was allowed.
He was allowed.
He was allowed. And after that, the financial creditors have not filed the fresh claim in context of the order of the NCLT. In the meantime,
See, normally, if the claim is filed and it is rejected, and this rejection is agitated before the adjudicating authority, and adjudicating authority says that yes, you should accept the claim, then RP has to accept the claim unless there is a change in the claim or the financial creditor requires that to be changed. Is that clear?
sir, why is breaking yours? You couldn't hear you.
Then stop sharing.
Yes. Okay, sir. Please continue.
So the last question is answered.
Sir, it was not. It was voice was breaking, sir.
Okay, I'll repeat it.
Yeah.
The creditor has filed the claim.
Yes.
IRP rejected it.
Yes.
Then the creditor approached the adjudicating authority.
Yes.
adjudicating authority approved
Yes.
that the claim has to be admitted.
Yes.
So there is no need of filing the claim again. The claim is already with the RP, and the application was against the rejection by RP. So once the adjudicating authority says that yes, you have to admit this claim, he has to admit.
Okay. Okay. Okay, sir. Second question is, sir, there was a going concern, and the company and the CD was under the CRP process. The rent was claimed by the landlord, but this claim was not taken as a CRP cost by the RP while the COC meeting was going on. Then those rent which is claimed by the landlord, can it be the part of CRP cost right now?
You have to repeat the first part.
Sir, there was a going concern,
Okay.
and the rent agreement and rent was claimed by the landlord, but by mistake, RP has not added that value in the CRP cost while putting the plan. After that, this summary of the total CRP cost has been submitted to the COC, excluding this rent part.
Okay.
And how this rent part should be treated further?
The claim was made by the tenant,
Yes.
the landowner.
Yes.
Yes, there is a judgment related to that, because it is the mistake of the RP. He has made the claim. So the claimant should not suffer from that.
Yes.
The successful resolution applicant has to pay him in proportion of whatever the ratio they have decided for payment to the creditors.
So should the RP call a COC meeting for admission of this CRP cost further?
You see, at what stage it has happened, it will depend on that. If the distribution is already done and the aggrieved person is approaching adjudicating authority or the COC, RP has to definitely bring it to the COC when he comes to know about this mistake, and the COC has to take an appropriate decision, and the SRA is also bound to make payment because he had made the claim in time.
Okay. Okay. Sir, one question raised by Mr. Rajan Garg from Mumbai. He is saying that I have a question as to verification of claims by the home buyers not yet handed over unit. Is claiming inflation.
आप ईयरफोन यूज कर लोगे तो बेटर रहेगा, आपके पास ये वही सीखो हो रही है थोड़ी, मेरे को आपका वो पूरा समझ में नहीं आ पाता है सर.
Sir, can you listen me?
Now your voice is very clear.
Okay.
The only thing is I am not able to see you.
Because the camera is a little bit far, sir. That's why.
Okay, now it's better.
Sir, the question came from Rajan Garg from Mumbai.
Yeah.
He's saying that I have a question as to verification of claim by the home buyers. Home buyer not yet handed over unit is claiming interest at the rate of 18% cumulative. What should be done?
What is asking?
His question is only this, sir. He is saying that there is certain verification of claim by the home buyers.
So verification of claim has to be by the RP, not by the home buyers.
And unit has not been handed over to the home buyers. And might be the landlord is asking interest at the rate of 18%. So something like that.
So that is not clear. If you can make a text, I'll read it.
Okay, sir. I ask the next question, sir.
Yes, please.
Sir, question is, will IBC affect actions under DRT?
Definitely, the moratorium is there. The moment the company is under insolvency, all the proceedings are stayed. And it can't continue under DRT.
Okay. Sir, next question is, what are means of submission allowed by the IRP? By post, by electronic means, or by hand delivery, or by advertisement in newspaper?
For operational creditor, claims.
Yeah.
Claims submission has to be for operational creditors by post, by hand delivery, or by electronic means. In case of financial creditor, it is only electronic means.
Second question, sir, is the invoice issued during CRP for the rate difference in the steel prices related to pre-CRP period. Whether to accept the invoice during CRP or to be take the amount is claim.
See, this is related to the pre-insolvency date. The transaction has happened before insolvency commencement. It is the rate difference which is being claimed by the creditor. So it can't be the current payment of the CRP. It has to be through the claim, because the RP is not supposed to make any payment for the dues as on insolvency commencement date.
One question is been asked, sir, is applicability of law of limitation from the IBC notification. Little clarification required, sir.
Any specific issue, or I repeat the things relating to?
No any specific issue. They want some clarity further.
You see, initially, one of the NCLET judgment held that the law of limitation is not applicable to IBC proceedings. Thereafter, Section 238A was added, which said that the law of limitation will be applicable to the proceedings before the adjudicating authority. And then there was a judgment of Honorable Supreme Court to decide whether this amendment will be applicable prospectively or retrospectively. So Honorable Supreme Court held that this amendment will be applicable retrospective with effect from the date when IBC was notified, that is 1st December 2016. Now the question is with the reference to the claims, because Section 238A talks about the proceedings before the adjudicating authority. Claim is not a proceeding before the adjudicating authority. Claim is submitted to IRP. And Swiss Ribbon has held that RP is not an adjudicatory authority. RP is in an administrative position. RP cannot reject or the claim like the liquidator can do. So the issue is very, it's a gray area for the RP, whether the RP can adjudicate on it. RP can very well say that it is within the, it is time barred, so he will not be able to collect it. And if the aggrieved party wants, he can go to the adjudicating authority for an order. And if the adjudicating authority says that it is not time barred, then he has to admit the claim. But if there is already a judgment which says that the debt is time barred, then the RP is not supposed to consider it. Is that clear now?
Yes, sir. One more question came, sir. Can ex-director be the part of COC? Question. Can ex-director be the part of COC?
A director can never be part of the COC, even if he is a financial creditor, because unrelated financial creditors can have voting rights. Related party will not have membership of the COC. The director, by virtue of the section, I think 21, which says that the notice of the meeting has to be given to the directors. By virtue of that, they can attend the meeting as observers, but they cannot be considered as the members of the COC. They don't have any voting right.
Okay. There are two more questions, sir. One is, please provide case laws where the income tax department claims are rejected after approval of NCLT order.
I have given you one example of the PF commissioner. Then there is a Supreme Court judgment, Moneth Ispat case, where it says that IBC will override the provisions of income tax where there is a direct conflict. And under section 178, during liquidation, there is a provision that you had to wait for the no dues certificate for 3 months from the income tax department. So that has been considered not applicable to IBC because IBC overrides income tax to that extent. So any claim which is filed beyond the timelines, particularly after the resolution plan is approved, then no government authorities claims are being accepted. There have been several cases. I think one was in the Rajasthan High Court, where the GST department made a claim after the resolution plan was approved. So they said it nothing doing in view of Ghanshyam Mishra's judgment in case of by the Supreme Court. It said after the resolution plan is approved, the successful resolution applicant has to have it on a clean slate, no new claims by any government department, be it income tax, GST, service tax, or any other customs even.
Okay.
Ghanshyam Mishra is a very clear case. It includes all creditors.
So the last question: if someone didn't submit the claim in Form B, can he may file claim in the liquidation process?
Yes, if the company goes to the liquidation, there is an opportunity to file a claim. And the provisions have been amended that if the no claim is filed, then the liquidator will consider whatever claims are filed during the CRP process. And then he has the right to admit or reject. It is not necessary that whatever claims filed during CRP he has to take as it is. Then he can use his judgment to admit or reject them.
Sir, at the time itself, and you have taken more than 50 questions from the delegates, and it was very thought-provoking. At the time they said, we are working on the claim proceedings. Now the time is approaching to 3 o'clock, so I hand over the proceeding to Secretary Madam Isrita for the further action. Hand over to Rita.
Yeah. Thank you both, Madhusudan sir and Vishnu ji. And thanks to Madhusudan sir for taking us today on a very important topic, that is claims, and taking us through the provisions, the aspects, and also deliberating on the important case laws related to the subject. As you had mentioned in the beginning itself, that this is one of the challenging area for a resolution professional. So, and by taking the questions, you also clarified the members' query on the subject. And thanks to Vishnu ji for moderating the session today and putting all the questions before the speaker and making the session as interactive as it could be. And so thanks indeed on behalf of the Committee on Insolvency and Bankruptcy Code to both of you, sirs, to Madhusudan sir and to Vishnu sir. And also thanks to all the members who have joined to this webinar today in such a large number. Thanks to all of you. Thanks again to both of you, sir. Thank you.
Thanks to you and to the committee. And the meaning of Madhusudan and Vishnu is same.
Yes, sir. Yes, sir. What a combination.
Thanks to all.
Thank you, sir.
Participants.
Thank you.